Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're doing a verdict search episode where we're going to research actual trials, actual settlements, and verdicts. And we're going to do it for a condition known as a dropped foot or a foot drop. A foot drop is a condition where the muscles that lift the front part of the foot, which is known as dorsiflexion, right? Where those muscles become weak or paralyzed, causing the foot to droop or drop, hence the name foot drop. And usually the causes can be nerve damage, such as injury to the peroneal nerve, which controls the dorsiflexion muscles. The other cause can be spinal cord disorders, conditions like spinal stenosis, spinal cord tumors, multiple sclerosis. Neurological conditions can also affect it, such as cerebral palsy, muscular dystrophy, strokes. Trauma could affect it, such as fractures, dislocations, or ligament tears. So let's get into some of the verdicts. What I'll do is I'll do a verdict search, and I'll check out the cases. I'll sort them by most recent, and I'll just put in the term foot drop. So we'll see cases all over, all over the country. One of the most recent ones was December 26th of 2024 in Pennsylvania in Delaware County. And it was a medical malpractice case where an undiagnosed leg fracture led to a permanent injury, the plaintiff claimed. And the plaintiff was a 61-year-old lady who worked in the bank, and she was diagnosed with a transverse fracture of the left femoral diaphysis. And so she claimed that the left femur fracture had originally been a stress fracture, but had gone undiagnosed by a radiologist who had read her x-rays 3 days prior when she presented to a clinic. And she also argued that the radiologist's negligence caused her to suffer a right femur fracture, a left hip dislocation, and an injury to her sciatica nerve. So she sued the radiologist, the medical group, and she basically argued that the standard of care was not up to par, that it was medical negligence. And she had her own expert, which you need in a medical malpractice case, in radiology, and that expert testified that the defendant incorrectly interpreted her x-ray, which led to an incorrect diagnosis and an incorrect management of her underlying condition. And according to this expert, the defendant's negligence allowed the plaintiff incomplete stress fracture to progress to a complete fracture during a normal daily activities. And the expert also concluded that had the plaintiff's incomplete fracture been appropriately diagnosed in a timely fashion, she would have been managed conservatively, such as a non-weight-bearing and periodic radiographic surveillance. Sometimes you get a boot or, periodic surveillance. And the expert also determined that her fracture required surgical fixation and hospitalization. Now, the defense argued that the defendant's treatment of the plaintiff met the standard of care. According to the defense, she had been diagnosed with osteoporosis over 15 years prior to her visit. The defense also argued that although she had been receiving a biphosphonate treatment for her osteoporosis, she did not inform the clinic or the doctor about this, despite being asked about her medications. And the defense's expert in radiology testified that without the history of long-term biphosphonate treatment, very subtle cortical thickening is difficult to appreciate and is often a normal finding. When appreciated, it suggests that there is weakness due to deterioration of bone quality, not that it immediately indicates fracture. And the expert concluded that it's a minute hairline fracture. It could not be readily identified, especially with her history of bisphosphonate was not made known. There was no breach of the standard of care by this radiologist. The injury was that she had an open reduction internal fixation of her left femur fracture. She had a left drop foot. She had residual ankle dorsiflexion, plantar flexion extensor, hallucis longus weakness, and she treated her drop foot with physical therapy and an ankle foot orthosis. The jury found that the radiologist was negligent and that the negligence was a factual cause of the injury to the plaintiff, and the jury awarded her $803,000. And it was broken down as $25,000 for loss of consortium, $25,000 for that, $48,000 for past medical costs, $80,000 for future medical costs, $194,000 for past lost earnings, $100,000 for future pain and suffering, $250,000 for past pain and suffering, $106,000 for past and future household expenses. And so her total award was $778,000 plus $25,000 for the loss of consortium. So the total was $803,000. And it was $1 million demand, no offer, 5-day trial. The next case is out of Florida in Sarasota, and it happened in September of 2024. And it had, a bunch of different injuries. A lot of these cases are not just going to be drop foot, because, when you search one injury, you get cases with that injury, but you have other injuries too. And here you have like fractured leg, scarring, other injuries as well. What happened here was that it was a serious motorcycle crash with serious injuries. They were offered $1.5 million to settle, and I guess they said no. They went to trial, and the incident happened in February of 2022. So she was riding her motorcycle home from work as a full-time nursing assistant, and a box truck crossed into her path, and she collided with the box truck. And the impact severely injured her right leg, resulting in life-threatening injuries. And she was a single mother of 5 children, and her leg was mangled. And the injuries were so graphic that the judge ruled against admitting pre-surgery photos of her leg into evidence, deeming them too disturbing for the courtroom. And the plaintiff's attorney said that the defense mounted a vigorous challenge throughout the trial, refusing to accept responsibility and instead attempting to paint the plaintiff as the party at fault. And they felt like the defense did them a huge favor by taking surveillance of her, that they did it on 7 separate occasions, including one occasion when I think that they thought they had some compelling evidence that she didn't need significant recovery, but it showed her walking about half a mile, walking, and where does she get to? Ultimately, she goes to pick up her kids from school, and she lives in a pretty rough area. He thought that that made the jury empathize with his client more. But anyway, the injury was a tibial plateau fracture, a fibular shaft fracture, avulsion, so a lot of really serious injuries, rupture of the ACL, the anterior cruciate ligament, the posterior cruciate ligament, avulsion of the MCL, the medial collateral ligament off the tibia, insertion, patellar tendon, avulsion. So all these serious injuries, and I think, she must have had also a dropped foot, because that's the search term. Actually, the jury allocated 90% of fault to the defendant, to the truck driver, or the truck, and 10% to the plaintiff. And the verdict was $8.5 million, so a pretty large verdict. $550,000 for past medical costs, $475,000 for future medical costs, $7,118,000 for future pain and suffering, $355,000 for past pain and suffering, for a total of $8.5 million. And it was a 5-day trial with a 4-hour deliberation. Here's a case out of New Jersey with a dropped foot, but there's some other injuries like an ulnar fracture of the arm, a radius fracture, femur fracture, tibia fracture. Because usually dropped foot comes along with other injuries. And this one was 1.488, $1,488,950. Here's a slip and fall at a restaurant in Texas. This is from January of 2024. And what happened here was a plaintiff was 70, was at a Houston Aquarium, a restaurant and aquarium, with her 70-year-old granddaughter. She basically stumbled and fell on a rowboat replica in a dark, crowded corridor and broke her ankle. And then she ended up also getting this dropped foot. She had surgery, including open reduction and a bimalleolar fracture. And the result here was $2,825,000. Here's another one with a knee replacement failure. And the defense argued that the knee replacement failure, although it led to a dropped foot, it was a risk of the procedure. And so the result here was, it was 0. No result, because I guess the jury believed that it was a risk of the procedure. Here's one where an orthopedist denied nicking an artery during knee surgery, and it was also medical malpractice. This is back from 2019, the date of incident. The trial was in December of 2023. And what happened here was a retired man in his 70s underwent a bilateral total knee replacement. And then the surgeon performed the procedure, and he complained of right foot pain, and he was diagnosed with acute right limb ischemia. He underwent revascularization surgery that included an arterial repair with fasciotomies. But basically here as well, they just found that there was no nicking of the artery during the surgery. And so it was a defense verdict. It was 0. So you can see, like, drop foot is a serious injury. You can get big numbers for it. It's just a matter of, whether you have liability. The reason that some of those medical malpractice cases are 0 is because, like, they're difficult to prove. Doctor's going to say, look, it's a risk of the procedure. Medicine is not an exact science. I can't give you a guarantee. I can't ensure a beautiful outcome. Sometimes things just happen. And so a lot of the times the juries sympathize with the doctors. Here's a case out of the Bronx, also in New York, from September of 2023. It was an iron worker who was required an amputation after a construction accident. So what happened here was he was working, he was 51, and it was a construction project at LaGuardia Airport, which was all brand new, it was reconstructed. Anyway, a 27,000-pound steel header allegedly fell on him, and he sustained significant leg injuries that required a below-the-knee amputation, but he also had a dropped foot. He had degloving, crush injuries, comminuted displaced tibial shaft fractures, real serious case. Now, what happened here, he had the dropped foot, but that was like probably the least of his worries because his other foot was amputated. And it was a settlement, and the settlement was for $14,500,000. So a big settlement. But he's going to have lost wages. Those cases are very good. Those cases you can get big numbers. And here's another one out of the Bronx. This is a vascular surgeon's negligence led to a leg amputation. And so what happened here was that in April of 2018, the plaintiff, who was an 89-year-old, underwent a thoracic endovascular aortic repair, known as a TEVAR. I guess 2 vascular surgeons performed the procedure while the plaintiff was a patient at Montefiore, and the surgeons attempted to cover her aortic aneurysm with a stent, and during the surgery she experienced uncontrolled bleeding, including rupture, perforation of her right external iliac artery, hemorrhaging, extensive hypotension, numerous complications from the TEVAR procedure, including right foot drop, thrombocytopenia, left leg ischemia, myocardial infarction, hyponatremia, cauda equina syndrome, T12 hematoma. A lot of injuries. So it was like a medical malpractice case. They had experts on both sides. For the plaintiff, they had a vascular surgeon, hematologist, and the defendants had one as well. So the result was that the jury determined that the doctors did depart from accepted standards of medical practice and that the doctors' departures were substantial factors in causing the injury to the plaintiff. And the jury assigned 30% of the liability to one doctor and 70% of the liability to the other. And the jury awarded the plaintiff $10 million. A pretty good result, $7 million past pain and suffering, $3 million future pain and suffering for 3 years, 9-day trial, 75-minute deliberation, 6-0 vote, 6-0, 2 men, 4 women, and defense counsel's motion for a new trial was denied. The defense also moved to set aside the verdict as excessive. We'd have to check the appeals to see what happened with that, but $10 million for a 89-year-old is pretty good, because it's really hard. Usually people say no to those cases because the people are so old, they think, they're not worth as much, but that's a really good number. Here's a case where a nurse claimed a comminuted neck fracture from a crash out of Cook County in Illinois. This was a May 11th, 2016 crash. A nurse was in her 50s. She was driving on Gateway Boulevard in Chesterton, Indiana. When she was at the intersection with State Road 49, her vehicle was rear-ended by a tractor trailer. And so she had serious injuries, a neck fracture resulting in tetraplegia. And so she had the fractured neck, fusion in the neck, fracture of the cervical, neuropathy, spasticity, physical therapy, comminuted fractures, epidurals, dropped foot, nerve damage, neuropathy, neurological impairment, all these injuries, tetraplegia, real serious paralysis. And the result here was actually a verdict for the plaintiff for $43,825,000. $800,000 for past loss of consortium, $1.7 million for future loss of consortium, $800,000 for past loss of services, $1.7 million for future loss of services. So $5 million for the husband, and for the wife, $1.2 million for past medical costs, $9.5 million for future medical costs, $450,000 for past lost earnings, $675,000 for future lost earnings, $5 million for future pain and suffering, $3 million for past pain and suffering, $10 million for future loss of a normal life, $3 million for future emotional distress, $2 million for disfigurement, $3 million for past loss of a normal life, $1 million past emotional distress, and $38,825,000 total. And then with the husband getting, I think, $5 million altogether, it's like 43. So yeah, that trial actually took, 9 days, and the offer was the policy, which was only $1 million. They gave the policy limit, but I guess the plaintiff's attorney didn't want to take it. I don't know if it was open, if he was trying to get more. The interesting thing also for me, as a lawyer, just reading it, is that they gave a lot of money for something called, loss of a normal life, and you get both future as well as past. Now in New York, you don't have that, right? You have loss of enjoyment of life. But I like that, loss of a normal life. Sometimes, each state has their own pattern jury instructions, where the judge uses his own laws, judge uses to instruct the jury, and then the jury will make a decision based on that. So sometimes it's interesting, right, to learn other states, and then maybe if you have a loss of enjoyment of life claim, you could use those words, or maybe use some of the words from another state, right? But just if they make more sense, if they're more appealing or persuasive to a jury, you could say loss of a normal life. I kind of like that. Wow, they lost the ability to live a normal life. So that's a powerful argument. Okay, I hope this was helpful. Let us know what other questions you have. This is just like some of the recent verdicts with foot drop. We could do some more. And we'll do some more verdicts about spine injuries, spinal fusions, brain injuries, and other conditions, maybe open reduction, internal fixations, bimalleolar and trimalleolar fractures, all types of injuries. We could also do, verdicts about certain areas, like a verdict for New York, a verdict for Los Angeles, a verdict for maybe Texas, and compare different locations. Okay, everyone, have a great day. Thank you so much. Please like and subscribe to our channel. We are here for you. Our goal is helping serious injury victims and families. If you have a case, I hope you get full justice. If you need a consultation, just text me. It's 347-566-9595. All the best. Okay, bye-bye.